Money Talks.
Money Talk.
Money Talks. Money Talks.
Hi, my name is Ibukun Oyedeji, President CFA Society Nigeria. Join me and a host of other financial industry practitioners for Money Talks with CFA Society Nigeria.
Money Talks.
Money Talk.
Money Talks. Money Talks.
Money Talks with CFA Society Nigeria. Let's talk about money. Hello everyone and welcome to Money Talks. Money Talks is brought to you by CFA Society Nigeria and is a financial literacy program. Smart. Uzechi is my name. You can call me Captain Smart. It will be financially correct if you call me Captain Smart. Today on the program, I have a very special guest. He's been here before, so we'll say time and again, once and again, he's back here on the program. I'm talking about Fakrogha Charles Oyinmiebi, who is a chartered stockbroker, broadcaster, a mortgage banker, and trainer involved in training and certification of dealing clerks. He's also a Securities and Exchange Commission approved person. Charles has over 2 decades of securities trading, assets management, and investment banking. He's currently the managing director of Max Fund Africa Limited, a crowdfunding firm based in Lagos. Charles has a BSc degree, you won't believe it, in chemistry and even biochemistry option from the River State University, and an MBA finance from Lagos University, Ojo, Lagos. And this evening we're going to be discussing estate planning for couples. But as our custom is, even though Charles has been here before, and these days you also hear his voice on the radio on Mondays in the mornings, let's just make welcome Charles Fakrogha to the program this evening with an applause. So Charles, welcome to the program. It's so good to have you again.
Thank you, Captain Smart. It's nice being on the show with you.
Yes, that's Charles. Very energetic. You can't not just but feel Charles this evening. So we're going to be talking about estate planning for couples. So if you are a couple or you're intending couple, you need to listen to this. This concerns everybody, and I can tell you Charles is he's just a reservoir of knowledge in this aspect, and I want you to milk him this afternoon, because when he leaves here you have to pay very heavy consultancy fees before you can talk with Charles. But as he's here this half hour, is all for free. Charles, one more time, it's so good to have you. How are you doing?
I'm doing great.
I can see. I can see you're doing great. Your voice is still sharp.
I'm inspired because I'm in Inspiration FM.
Absolutely. So good to have you. So Charles, let's get this program started. But before that time, is to let you know, the listener, you can get in touch with us at any particular point in time. You can call the telephone number 0700 923 923 923. That's 0700 923 923 923. You can also call us using the WhatsApp number 0817 313 6193. That's 0817 313 6193. You can send a WhatsApp message there, send a voice note there, or you can just drop us a call on that number. Whatever you do, just be sure you're getting in touch with us here this evening. So Charles, very quickly, when people are talking about estate planning and all of that, let's start from there. What is this estate planning, and why do you think it is essential for couples, and how does it help protect both partners' assets and financial well-being in the relationship?
Thank you very much, Captain Smart. You see, when you talk about estate planning, is one of the plans when you are talking about financial planning. Just as you have your investment plan, savings plan, your risk plan, insurance plan, estate planning is just one of those plans. And what does it entail? It entails where an individual decides that, yes, I want to plan how my assets will be distributed when the good Lord calls me. And when I say asset, it could be tangible asset, it could be intangible asset. All the things that this particular person own. When the good Lord calls him, how is it going to be distributed? So he's going to put that down. But for couples, yes, we encourage them to have, you can have a joint will, yeah, which some people call a mirror will, where each partner will say, okay, when I die, all what I have goes to you, you know, just like that. That's a joint will. Now, the two of them must come together to agree before they can have that kind of joint will. It's just like a joint account. Yes. So they know that all the asset that they have belongs to two of them. So, if one partner, the good Lord has called one partner, then everything automatically reverts to the surviving partner.
That's why people don't like to talk about this thing, Charles. Because when they reach when I die, nobody wants to talk about when they die.
I've had this in several fora. People ask, immediately we begin to plan our estates.
Now we say,
I'm going to die the next day. No. It's agreed on African, but we are saying the reality is on ground now. You can't imagine a man dies on the Friday. On the Monday, the husband people have come to collect everything, and share the children don't have anything. So we are saying, and the man is somewhere, he will not be happy. We want his soul to continue to look to and go to paradise.
And why is it that people always think that the man dies first?
That is a very important question. Yes, and I'll tell you why. One, marriages, usually the men are usually older. In terms of age older, so it's expected that the older ones will die before the younger ones. But again, we have seen cases where the woman can die before the man. But at the end of the day, it is good that they have an estate plan which takes care of everything when they have gone, how it has to be distributed among their loved ones or beneficiaries.
So you're clearing the air now that the fact you're entering into this sort of thing doesn't mean that you're inviting death or you're going to die the very next day.
Okay, Captain Smart, you know, I don't want to be spiritual here now. Death is one thing that every human, like just like I say in biology, I know I taught biology sometime, death, we call it Mr. Niger D. After all the characteristics, death is that D. Every human being, every living thing must die. So it shouldn't come as a surprise. We should just prepare ourselves, and that is why we are saying do this estate planning while you are alive.
Wow. So you just mentioned a term now, that's mirror will. I want us to dwell on that a bit. So you're going to tell us the primary differences between creating separate wills where the man has his own and the woman has his own versus this joint or mirror will you're talking about for couples.
Okay, when you say a separate will, you know, the man has his own will.
Yes.
And what he has there, he has written everything, how he wants his assets to be distributed among his loved ones. Is there, of course, the will has to be valid, it has to be written, except in some cases you don't need to write, it doesn't need to be written. And there must be weaknesses to that will. Okay, once you have satisfied that, there's okay, it's a valid will. Now it's only his property, his assets that is on that will. So anything happens to him, of course the lawyers will tell you how to go to probate registry to give force to that will, so that whoever he or she has appointed as the executor will now begin to manage the assets and now begin to distribute and of course pay taxes as the case may be. That is for the man's will. Now when you now talk of a joint will or a mirror will, now when you say mirror will, the man is saying this property, if I die, goes to my wife. The woman is saying this property, if I die, goes to my husband. That is the mirror will.
Okay.
You know, everything is identical. It could be on one sheet of paper or it could be separate document. And that is why, because what is in here mirrors what is the, that's what is called a mirror will. But obviously just simply a joint will where both couples have agreed. Now you will ask the question, what happens if
two of them die? There's a joint debt.
Of course there is a joint debt. Of course they have beneficiaries that they have listed on that will.
Okay.
What will happen now? The executor, as it is a will, you also know that most of us don't write will and we die. In that case you have an administrator that will be appointed by the court. They will also now look at what's on that will and distribute according to the desires of the testator. That's those who have written the will.
Okay. It's getting interesting in the room here, in the studio here. So if you want to join the conversation, perhaps you have questions around estate planning or maybe wills right now. You want to write a will, or you've written one, your late parents wrote a will, you want to access it, you're having troubles trying to access it, you can call the telephone number. Join the conversation here, 0700 923 923 923. That's our number to ask any question around this subject, or you can call 0817 313 6193. You can call it on WhatsApp. Just send us a WhatsApp message as well, or send us a voice note. Charles Fakrogha is our guest on the show this evening, and I can tell you he has the answers. So Charles, how should couples approach coordinating their estate planning documents? Because I reckon that a lot of documentations will be involved in what you're talking about. These documents like wills, trusts, and even beneficiary designations, so that in the end there won't be conflicts, because these things sometimes they lead to conflict.
Of course, you are very correct, and that's why we must give kudos to CFA and of course Inspirational FM for running this kind of show to avoid conflict. It's very key, because marriage should be sweet. There should be enough communication in the marriage. The couples need to come together.
Yes.
Advice usually is talk to an estate attorney who will advise, looking at their circumstances, and say, okay, these are the instruments you need to use. The most important thing, there must be communication. The couples must agree. Now you're talking of beneficiaries. Yes, the wife can say, I want this thing goes to this person. The husband can say, I want this thing go to. So they must come to an agreement for any estate plan to really work. And that's why, like you said, most people prefer to do a separate will. Yes, a separate will, so that where they have complete control of how they want their assets to be distributed. But again, we are saying you must carry your partner along.
0700 923 923 923. That's the number. That's 0700 923 923 923. You can call that number, or you can also call us on 0817 313 6193. That's 0817 313 6193. Call it on WhatsApp, send a WhatsApp message there, or just record a voice note and send to us here. If you have any questions or you want to make a contribution to the program, you're also welcome to do that. So Charles, how can couples plan for contingencies, such as one partner becoming incapacitated, or the impact of divorce on estate plans? Because when people are making these plans, they're writing wills, they don't envisage that they're going to be divorced. But that can be a contingency.
That's the reality of life.
Yes.
It will happen, and I don't want to sound as a broken record to say most marriages now don't even last up to 1 year. But if they attend my class, I'm sure it will last for a lifetime.
Yes.
As a marriage counselor. Yes, the couples, you need to plan for contingencies. It's very obvious. You need to have what we call durable power of attorney. That is, in the event of there is an accident, and either the man or the woman becomes incapacitated, that will have been taken care of. To say, okay, I want my partner to deal on my behalf when it comes to my financial issues.
Oh wow.
That's, yes, you can also have that. Then you can also have a trust for asset protection and management. You can have a trust. And what is a trust? The husband and wife, okay, can be part of the beneficiaries, where they are also the creator of that trust. All the properties that they have, all the assets will be owned by the trust. They become the trustee. Okay, now that means they will continue to benefit from those assets while they are still alive, and when they die, it will just pass to other beneficiaries. So they have the husband and wife as part of the trust, then they are beneficiaries. The benefits will continue to flow even when they are no longer here. As in the case where they cannot write a will, or they don't want to write a will, But they must be transparent, because you must put all your assets in that trust. Today we have corporate trustees. They are experts in arranging that type for couples and all that. I will advise that couples can also approach those institutions who are vast in that area. Of course, an estate Anthony can also advise them on what to do. Now, when there is a divorce, there is also an issue there. There is a plan already. They will have agreed in the case of divorce. And that's why when you are doing this thing, you talk to your estate Anthony. That's what happened. But you know, that's what they call prenup. There are agreements you have before the marriage. Now, if they are saying this property, this asset, I own them before this marriage, which will not be part of our estate. Only the ones that we acquired together will be part of this our estate. Fine. Or if they say, okay, whatever I have even before marriage, after marriage is still for both of us, they agree. But in the case of divorce, then they will say, okay, 50-50 as the case may be. As long as there is an agreement. Divorce does not make your partner becomes an enemy. It could just be irreconcilable differences. And for your own health and for the sanity of both partners, maybe just go your separate way. You still have, maybe you have children. I mean, God has blessed that relationship with children. You are not enemies. You can just amicably agree to say, okay. And all that will have been written earlier before that event occur. And so when it happens, the documents are there. The lawyers will just come, and then the properties are shared according to the agreed formula. Usually we advise 50-50.
Okay, there's a message here. Meanwhile, you can call us on the telephone in case what you're hearing now, you have questions or you want to make a contribution, maybe share an experience. You're welcome to do that. 0700-923-923-923, 0700-923-923-923, or you can call us on 0817-313-6193. You can call the second number on WhatsApp or send a WhatsApp message there. You can also record a voice note and send to us. But voice calls 0700-923-923-923. Sam here says, Mr. Charles, thank you so much for the insight you're bringing. My question is, after making this will and I divorce my wife, can I cancel the provisions in the will since she is no longer my wife?
Okay, like I said, when you were preparing the will, you are talking to your estate Anthony. Now, once you are divorced already, then that will no longer be valid. Yes, because there are provisions that she's also going to have based on that will you have written. And nothing says that because you have written a will, you cannot review it as long as you are still alive. Imagine if you have just one property, one house in Lekki, and God bless you, you have another one in Abuja, but you have written your will already. You can still include, so you review your will based on the advice of your estate Anthony. You can review your will. So if you have divorced your wife amicably, of course you can review your will.
You can remove her.
You can review. I didn't say remove. You can review the will. Yes.
This person is asking, she's no longer my wife. What if I want to remove her?
Fine, you can do that. Because you can remove a beneficiary
where the property is yours.
Yes, when it is yours.
Okay.
Yes. And that's why there must be an agreement as to the assets in that will. Two of you must have agreed. You might even have a child.
Yes.
And because you want the child to do certain things, the child goes astray. And the child is already a beneficiary in your will. You can decide to change it
and remove the child.
Yes, it's possible. You can review it as long as you are still alive. Your will is what we call ambulatory. It only takes effect when you are no longer on this planet. It's now speaking for you while you are now trying to go and talk to your creator and go and relax in paradise. So there will be no trouble here. People will be happy as to what you have distributed to them, because according to your desires, what you want, and that to be fulfilled when you're no longer here.
There's a lot of education this evening, and I'm sure the audience, they are actually getting a whole lot. Remember, you can join the conversation. You can ask questions of Charles. 0700 923 923. That's the number to call us here. So Charles, how can you talked about executor? How can couples choose an executor or trustee who understands the unique family dynamics and estate planning goals? Because sometimes people are dead, and then, like what they say in local parlance, Kasala will just boss. Hello, good evening to you. Hello.
Good evening, Captain Swap.
Thank you so much for calling.
And Mr. Charles. My name is Femi. I'm calling from Lagos.
All right, Femi, quickly, let's have your contribution.
Yeah, I believe that Mr. Charles is talking from the administrative part. Now, I want to ask along with that, okay, let's assume that there is a parent, and then there is a child outside of the wedlock. Can the child consent that will?
Okay, Captain Smart.
Yeah,
Rephrase the question.
if there's a child outside of wedlock,
Yeah.
Whether the child can benefit
Can
from.
the child now come to contest the will?
okay, can the child come to contest the will if the child had been born outside of wedlock? That's his question.
Okay, the father has the right to put whoever
He wants.
he wants in his will. And if that child out of wedlock is not in that will, the child cannot come and claim anything, because this is what the testator has written, and nobody can change it. So, however, the beneficiaries, out of compassion, I said, okay, this is also our relation, we can give him something. But you know, there are some wealthy people, they've already willed all their assets to charity, and they have children already. So those children cannot come and begin to contest that will, as long as it's a validly written will. It met all the requirements for a valid will. You can't contest it. Of course, talk to your estate Anthony, and you go to court and know whether you can contest the will.
So you don't have to be the child of a testator to benefit from their will.
Of course, a wealthy man can will his property to his company, his secretary in his office, if he has seen that she has done quite well for him, either in kind or any other way. He can decide to say, I am giving this to my secretary. Fine. I'm also willing so amount of my asset to a particular charity that meets its own values. So the testator has the right to put whoever he or she wants in his will.
I see. So choosing an executor.
Okay.
Yeah.
Yes. When we see an executor, that is somebody that is given that legal right to administer the estate, and it's as a result of a valid will that has been probated through the state high courts probate registry. He has given it authority now. So the executor will now see how to realize the estate, pay the liabilities, pay tax, and also begin to distribute to the beneficiaries. That is for a will. That is the executor. Now, for an executor, you don't need to be paid. So it is something you are doing out of love for that particular testator. However, you can also be a beneficiary. That's the executor. Can also be a beneficiary in that will.
Yeah.
You know, or if it is written there clearly. So, but the executor, I always advise, make sure that those you are going to make your executor are people who understand your unique family circumstance, who understand the process, and ready to take some of the liabilities and of course some of the benefits that will accrue. Because some testator will say, after you have distributed everything, what is now left goes to the executor. And of course, the executor does not even need to be so close to the testator. That's the writer of the will.
Oh wow. You've been speaking about power of attorney. Let's talk about that a bit. So you can tell us now what power of attorney and healthcare directives are most important for couples, and why should they be part of every estate plan?
Yes, it's just to plan for contingencies. Anything can happen. That's why we mentioned earlier the power of Anthony. It could be a durable power of Anthony, where you say, if anything happens to me, I'm incapacitated, then the person you have named who can act on your behalf in your financial, if all your affairs can act on your behalf. You can also have an healthcare power of attorney, authorizes you to make medical decision in case of incapacitation. Maybe they need to do a quick operation and the person there is no longer conscious. Some people will say, don't keep me for too long with an oxygen. As soon as the doctors have said there is no way I'm going to survive, then don't waste time on keeping me alive. So the person you have named can use that power of healthcare to say, this is what this patient wants, and it will be executed. Not that they are helping you to die quickly, but that is according to your wish.
Oh, wow.
It is what you want. You can also have the Advanced Healthcare Directive, combines living will and healthcare power of attorney. So what they are saying here is, as you are planning your estates, it is not just only your assets. Anything can happen to you, and if it happens to you, who continues from there? So if all these things are already written down, then it becomes easy. Even yourself, as you are transiting to the other realm, you will be going with a peace of mind, and it will just flow to the other realm, and you continue your journey to paradise, as the case may be. Or because we have not been there and come back before, but you will not be coming back, to disturb people on earth now, because you are not fulfilled. So the ball is in your court. As we are all alive today, we can now begin to think of it. Talk to your estate Anthony today and see how. You don't need to be a wealthy person. You don't need to say you want to own everything, or I want to get married first, I want to have children first. No, as long as you earn an income, you can begin to plan for your estate. As simple as that. I have done one already.
Okay, I would like you to answer this in 30 seconds, because you kept talking about the changes that can occur in these things. So tell us the steps, just maybe one or two because of time, that couples can take to ensure that their estate plan reflects changes in their family situation, like when more kids are born, or a beneficiary dies, or maybe a child behaves recalcitrantly. Then I'll say, this boy, you don't deserve anything I own.
Of course.
Just very quickly.
Even lawyers will tell you, you have written a will, it's not cast in stone. As long as you are alive, you can review. Well, lawyers will say review. Me, I always advise review as your circumstances improve or changes. You have 2 children. You gave birth to another child. Of course, you must include that child in that your plan. So you review, and in reviewing, you don't even need to write another new will. That's what lawyers call the codicil. It's like an addendum to your original will and testament. So you can it's an additional. You just write it, take it to your lawyer again, and of course it will be attached to that your original will. So you can make changes, review at any time. Your lawyer does not need to advise you, say, okay, every 3 years, every 1 year. No, it depends on you. You could have a change of mind and said, no, like you have said, this child, you are not behaving the way I want you to behave. You can change it.
Or you can marry a new wife and you want to include your wife into the new will. Okay,
of course.
We have run out of time. I know you have scared a lot of people today with this your vibrant. You have scared a lot of people. I've scared. I've seen messages here, but that's where we're going to leave it today on Money Talks. Until next time, Mr. Charles Fakrogha is a chartered stockbroker and investment banker. Many things in one. Thank you so much, Mr. Charles, for coming this evening. We appreciate you. I hope that very soon we'll have you again. God bless you for coming. Thank you so much.
Thank you for having me, Captain Smart.
And that's the program today. We'll be back next time. Till then, keep